Hey everyone, I am really excited about today's show as I have a great guest with me, Ann Kiernan of Kiernan Law, and we're going to discuss the lessons learned from poorly conducted internal investigations. You definitely don't want to miss this one.
Welcome to the HR Investigations Podcast, exploring the issues, challenges, strategies, and solutions. Sponsored by RPCHR and hosted by Natalie Ivy, an HR consultant, licensed PI, and author of the best-selling book, How to Conduct Internal Investigations, a practical guide for human resource professionals. And now, here's Natalie.
Hey everybody, I am really glad to have you at my podcast today because I've got a special surprise for you. I have a guest with me, Ann Kiernan, and Ann is an attorney, and she and I have moved in the same circles for, probably 15 years or so, and teaching continuing education programs. And I have asked Ann to join my podcast today so that we can talk a little bit of shop about really what happens when we really have poorly conducted investigations. And she's going to share some of her expertise on really kind of what happens when there are some of those legal ramifications. Now, what I'd like to do is turn it over to Ann. Ann, if you can share with our listening audience just a little bit of a brief bio about you, then we'll talk some shop.
Hey, thanks, Natalie. Yeah, my name is Ann Kiernan. I'm an attorney in Central New Jersey. And my background is I started out as a law clerk in federal court, and my judge had multiple sclerosis. And that really tuned me into the abilities of people with disabilities and got me started in a career in employment law. But after that, I've worked at a firm representing employers, handling all kinds of business litigation, not just employment law, patents, copyrights, trademarks, insurance fraud. And then I was a partner at an employee-oriented law firm. So I've tried to see both sides of these matters, Natalie. As I know you know, it's important in internal investigation to remember that even the thinnest piece of paper has two sides, right?
Very good. So, Ann, let's talk about the perspective from legal counsel. What happens when organizations really don't train internal investigators on how to properly work cases? Let's start there, and then we'll delve into some more legal ramifications of that.
Well, I'm sure you know, Natalie, the old saying that failing to prepare is preparing to fail, right? You've heard that one.
Yeah.
and that's exactly the same here. If we set people out to do a job who don't know what they're supposed to do and don't know how to do it, we really shouldn't be surprised when the job doesn't turn out right.
Yeah. And what I find in my travels, and for my listening audience, you know that I'm a licensed PI and that I've been doing investigations for a long time, and that I also provide training for organizations on investigations. And one of the things that I find really tricky is knowing when to conduct one. And these days, some organizations are conducting investigations into absolutely everything, even just kind of minor issues like my coworker took the stapler off my desk and didn't put it back, and I'm being subjected to a hostile work environment as a result of that. And then we also have, of course, super serious cases. But, there's a very big difference in launching an investigation and collecting evidence and involving legal counsel and, preparing possibly even to separate an employee because of really egregious misconduct. That's a whole other ballgame than just my coworker didn't put the stapler back. But, I find that a lot of HR professionals and employee relations, they struggle with knowing when to launch it. So I spend a lot of time with that. Talk about the more serious things that do come up, like allegations of harassment or discrimination. What are some of the legal ramifications for employers and when organizations don't handle those types of cases effectively?
Well, as you point out, Natalie, not everything is a federal case, right? Somebody took my stapler, somebody took my lunch out of the refrigerator. Those are employee relations matters, and we certainly have to deal with them. But that's a long cry, as you correctly point out, from allegations that could get the organization in serious legal or compliance trouble. Like allegations of harassment, discrimination, safety violations, financial irregularities, theft, those sorts of stuff, which can get the company in legal trouble. I would think those would go to the top of any list in terms of matters that require a, well-done professional investigation.
Yeah. So how about maybe negligent investigation? Can you kind of talk about that a little bit, where an organization may find themselves on the losing end of a negligence claim?
Well, let's start out with the basics. One of the first things you learn in law school is the definition of negligence. It's duty, breach, causation, damage. You have a duty to do something, you breach it, and that breach causes damage. I'm driving a car. I have a duty to keep a safe distance from the car ahead of me. If I breach that duty by tailgating and I rear end them and cause damage, I'm liable. Duty, breach, causation, damage. I'm a surgeon. I need to take out your right kidney. I take out the left kidney. I've breached my duty. I've caused damage. So same here. There's a duty to do this the right way. And if you breach it and cause damage, you're liable.
Mm-hmm.
So how can you breach that duty? Well, a couple of ways. Failing to investigate at all, ignoring complaints, which can cause liability. That's one problem, failing to investigate at all. Or having an investigator who's already made up his or her mind about the subject. We know a case, because I also do training on internal investigations. Of a case where they tell the subject, don't bother explaining, we already know you did it. Well, that's not an investigation. That's already a conclusion.
Yeah, absolutely. That whole bias thing, that's one of the things that I talked about in an earlier podcast episode with why a lot of organizations are moving towards centralized teams. They're really wanting to get away from that HR business partner generalist who has the day-to-day responsibility for payroll and benefits and the myriad of other kinds of disciplinary action that may come up because of performance issues. That's really a little murky, especially because of the cozy relationship that also exists with those HRBPs. So a lot of the businesses now are starting, especially larger organizations, I'm seeing that centralized team where they're training them, and that's all they do. They work cases, they get to their findings, they present the report, and then they go on to work a case another day. And they don't really have that sort of preconceived notion because, I dealt with Ralph last week in a write-up, and I already know that Ralph is guilty. I already know that he did it. That mindset simply because they may even not particularly care for a particular employee. They, have formulated an opinion about them, and and that's very dangerous. So for the listening audience, those of you who are HR business partners or generalists, this is something that you really need to be thinking about too. If you really kind of look at the case from the outside looking in, even though you yourself may be very objective in handling a case, let's say with this guy, Ralph, you may feel like you could do it, but it isn't really about you, right? It's really about the perception of what other people think. And particularly from where a complainant is sitting, if they really think, oh, well, all I have to do is run to HR and I can get Ralph in trouble, or conversely, you could have a complainant who legitimately is bringing forth a claim, but maybe you are a little biased because that complainant has made previous allegations, right? And you're just completely not wanting to buy whatever their story is. Okay, that's bias. And so if you find yourself in this situation, this is the time that you really do need to be reaching out to legal counsel, right? And
that's right.
Yeah. And if it were you, Ann, you would probably be recommending a different type of investigator, wouldn't you?
Yeah. And that doesn't mean there's anything wrong, that you've done anything wrong. You can't help being human. If you know somebody, if you've got a relationship with them, if you've had a past bad experience, you can't help that. But what you can do is recognize your bias and excuse yourself. That's the professional thing to do.
Yeah.
And get somebody else. Nobody is so unique that they can't be replaced by somebody else. And we got to remember, the investigation is not just to resolve the internal problem you have. It's for that, but also for the outside world. If this gets looked at by a court, by an administrative agency, by even a plaintiff's lawyer, and I can tell you as a lawyer, having represented employees, one of the things that will discourage a lawyer from taking a case is a well-done internal investigation. I've had that presented to me. Somebody came in, they brought the results of the internal investigation. I read it and I said, well, what do you want me to do with this? What am I going to, do you agree with, I did all these things. Well, what do you want me to do? I'm not a magician. What I did was negotiate a severance package because that was the best result possible in that circumstance.
Terrific. So in that situation, did they send over a copy of their report, or did they give you somewhat of a summary?
No, I had a copy. They had written. It was actually what it was. It was a final warning letter based on an investigation. So I did have that, and they offered him a severance package, and I said, "Take the money and run, pal." But that's why the client had a copy of it, because it was contained in a final warning, which did outline the nature of the matters that were the issue. Yeah.
Right. So now I'd like to shift gears just a little bit. So, Ann, from your perspective, and having been an attorney for as long as you have, and your experience in specifically litigation, can you give our listeners some examples of some employer lessons learned from mishandling, especially in maybe cases of harassment or discrimination?
For instance, we had a case that came up just a couple of years ago. There was a bring your child to work day, and somebody brought in their 15-year-old daughter, and a division executive made a number of very sexual remarks to this high school girl, right? And the mother of this child complained, and so did two coworkers who went to complain about this. Nothing happened. All of them got fired 6 weeks later, allegedly for poor performance. Anyway, there was no investigation. The case was brought claiming retaliation. Well, a jury agreed. Went to a jury trial, $500,000 in damages, plus almost $200,000 in attorney's fees. That tail can wag the dog. And that case was affirmed on appeal. So it's almost $750,000 awarded. And don't forget, there's going to be attorney's fees on appeal, too. So let's say more than $750,000 because nobody investigated. Nobody investigated.
Wow. Yep,
and these were serious matters, and not just the mother complaining, but two coworkers were also witness it. So we had two impartial witnesses.
Yeah,
and that case is 2017. So this is not exactly ancient history.
Yeah, so this is a fairly recent case. Yeah,
federal appeals case. Yep,
definitely there was some retaliation. It certainly looks like there.
Yep. Or the case where a woman complained about having to work with a male coworker at night. This happened in October. She told her supervisor, who did nothing about it. In fact, he said, "Don't tell me, I don't want to know." He actually said that. And the federal appeals court said, "We do not approve of this ostrich approach, ducking your head in the sand, pretending it doesn't exist." And I quote from the opinion, "The supervisor's purposeful ignorance will not shield liability." So in other words, burying your head in sand does not make the problem go away. It makes it worse. And this case happened in New York, and under New York state law, unlike federal law, under state law, individual supervisors and managers can be personally liable for aiding and abetting harassment, helping them out by not properly turning it over to investigation. So this is an area not only where there can be corporate liability, but even individual liability for supervisors and managers.
Yeah, excellent. I'm glad you brought that up. So what are you seeing in terms of, like a case you just illustrated? What are you seeing in terms of personal liability, in terms of monetary damages?
It's hard to track those because the opinion may not separate out who's exactly liable for what. But whether that the New York case I mentioned to you that came up on a preliminary ruling, whether he actually was found liable, I don't know. But it's certainly a powerful warning saying "Don't tell me, I don't want to know," ignoring complaints, not following policy. Give you another example. Last year, 2022, in Virginia, supervisor was told by his assistant, "Hey, Mr. A and Ms. B are having an affair." And he said, "How do you know that?" "Oh, Ms. B told me." Company policy required that, romantic relationships between supervisors and subordinates be reported, but he didn't report it. Other workers did, and it got to the CEO, who did order an investigation. As part of the investigation, Richard, the original supervisor, got fired for failing to report the affair. His defense was, "Oh, I didn't think I should just report a rumor." And the court said, Policy clearly said you had an obligation to bring this up, so it could be investigated. Termination upheld.
Mm-hmm.
And that was in Virginia, which is a very pro-employee state, unlike New York.
So let's talk a little bit more about cases involving discrimination today. So what are some of the key things that you are seeing with lessons learned regarding discrimination? And maybe, we can look at several different types, whether it's racial or whether it's dealing with equal pay or religion.
These problems are not like fine wine or good cheese. They don't improve with age. They're more like fish. They stink when they've been around the place a while. So a good investigation, the gold standard is start within 24 hours. Yeah. Delayed investigations can be painful. Give you a recent example of a case out of the Philadelphia area. Woman reported sexual harassment by a coworker, including touching, but nobody investigated. That was in December. In March, she tells another supervisor that Jose, the man who had been harassing her, and another coworker were retaliating. But nothing happened. Instead, she in fact got reprimanded. That was in March. In June, she again reports harassment by the same man, and they finally fire him. So this is after 6 months of harassment. And the court held that's not it. She's going to get damages because they breached their duty. We talked about duty, breach, causation, damage. And the court held they breached their duty to her when they failed to do a prompt investigation to remedy the past harassment and ensure appropriate supervision of this guy to make sure he wouldn't do it in the future. So that's a case we talked about, duty, breach, causation, damage. There's one right there.
Yeah, absolutely. And, when we refer to remedies, let's make sure that our listening audience, especially some who may be newer to HR, can you talk about that word remedy a little bit, Ann? And
sure.
From a legal perspective, what are some best practices for organizations?
Well, the idea of the law, civil law, is to put the person back where they would have been if the bad things hadn't happened, like putting Humpty Dumpty back together again. So we want to compensate for what they've lost, and that could include things like lost wages, value of stock options in publicly traded companies, medical bills, relocation costs, job search costs, that sort of thing to compensate for a loss, front pay going out towards retirement, back pay for the past. And courts also have the power to do things like issue injunctions, a cease and desist order, requiring changes in policies, requiring hiring, promotion, etc. So courts can be very creative in their remedies, requiring training. One of the things that the EEOC, the federal agency, does in every single settlement is require the employer to do training. As you know, Natalie, smart employers do their training so they don't get sued, not as a punishment for after they get sued.
Yeah, absolutely. To me, I call that my helmet principle. It's kind of like a motorcycle rider. Those who continue to ride, and I live in the Daytona Beach area, so it's kind of Harley capital of the world. You get people out riding a bike without a helmet on. Well, they go out and they ride the bike, but what happens? Like a friend of mine laid down his Fat Boy Harley on the Black Canyon Freeway in Phoenix a couple of days before his wedding, I might add, and really, really got banged up. John was a guy that never wore a helmet, but after he laid the bike down, what do you think he did? He started wearing the helmet. So what I see as, organizations that have been sued, and one of the things we specialize in is providing training to organizations to meet their EEOC consent decrees. Unfortunately, one client that I worked with, they got really walloped, and it was $16 million. It was substantial. And, they made some very significant changes, and I'm very proud of the changes that they made. But their decree required training for 4 years in a row with anyone who would be required to conduct an investigation. And they had to learn in the training curriculum all of the laws that the EEOC enforces, and they also had to have specific internal investigations training. So when we talk about some of these remedies, it's certainly better for you to just be proactive, to put that type of training in to begin with. And, one of the things I'm noted for saying in the HR community, and, there's best investigations, one you don't have to do.
Yeah. And please call your lawyer before you make the stupid mistake instead of afterwards. We'd appreciate it. It's a lot easier to help you if you call up and say, I want to do this. What do you think? As opposed to I did this, So please call us in advance. And, building on what you said, I often make the allegation that what I like to practice is preventive law, like preventive medicine. You want to keep your cholesterol low. Same with here. Let's keep you in good health so you don't have to have a quadruple bypass. You don't have to have a federal litigation.
Yeah.
So that's how I view it, is a good practice of preventive law.
This is why I love you, Ann. I could talk shop with you all day. All right. So in the last part of the podcast, I'd really like you to share a little bit of your experience with our listening audience. Yeah. Around, once an employer has been notified of a lawsuit and maybe, even an employee who's been separated from the company, can you kind of explain that process and a few tips?
One thing, Natalie, is, you point out someone who's been separated. In my experience, and I think of my clients, what's even more difficult is having an employee who is currently working for you who has brought a claim. because that creates some incredibly complicated issues of retaliation. So, a litigation with a current employee is much more perilous than litigation with an ex-employee, because you still have to deal with them as an employee, and you have to make sure you're doing appropriate performance management, et cetera, without it looking retaliatory. So talk about walking a tightrope.
Oh, absolutely. As a consultant, I would definitely have weighed in on some of those conversations.
Yeah.
Let's say when you are in receipt of a lawsuit, so whether it's a current employee or a separated employee, what's kind of the sort of step one?
Number one, call your lawyer. Number two, call your insurance company. Number one, call your lawyer, let you know, because the most important thing your lawyer can do is get you an extension of time. That's the first thing any lawyer is going to do getting in, is get you more time. So the lawyer has a chance to analyze the situation. So number one, hire a lawyer and get more time. Number two, call your insurance company. See if you have coverage, because that may dictate what lawyer handles it, how they handle it. If you carry EPLI, Employment Practices Liability Insurance, does your policy cover that? EPLI doesn't cover everything. EPLI probably does not cover wage and hour claims, for instance. It won't cover punitive damage claims, but it may well fund your defense, pay for your lawyers. That would be step number two, is call your insurance company. Step number three, put a freeze. Immediately stop all routine destruction of records, et cetera. I just this morning read a case where a company got sanctioned because their employee destroyed texts that were supposed to be preserved during a litigation. So please put in a freeze order, a litigation hold, stop all regular destruction of records and preserve all the records, because having records missed that are needed is terribly problematic. I have had clients held in contempt in federal court. It's no fun for anybody. And once you've done that, put a freeze on, then if you haven't done an internal investigation already, it's certainly time to start one.
Yeah. Yeah.
It's rare that you get a lawsuit where you have had no inkling at all of a problem. That's rare. It can happen, but it's rare.
Yeah, I agree. Usually some aspect of performance management is usually what I see. And then that tends to spark it.
Well, you've seen it, Natalie. People get written up, put on a plan, and all of a sudden, FMLA, workers' comp, like mushrooms after a spring rain, they show up, right?
Oh, I love it. In our final wrap up, so any specific best practices or tips that you can share with the group on working with legal counsel?
Please tell us the truth the first time. It is very, I understand people always talk about things from their own perspectives, and I understand that. But to have a client who doesn't tell you the full story makes it much more difficult to represent you. We're here to help. So you've got to tell us the bad parts as well as the good. So please tell us the truth so we can help you best. It may not be as bad as you think. Be open with us. The more work you can do as a client, the less we have to do as a lawyer. So if you will review your documents before we get them, that makes our job easier. So it's to be a teamwork. A good lawyer is your teammate, and there should be joint decision making. The lawyer will give you the legal aspects, and then you weigh in on your corporate values, your whatever your business strategy is, and try to come to the best solution. So in the best analysis, it's a good team.
Fantastic. As always, Ann, it's always a pleasure.
Oh, it's always a delight, Natalie.
Oh, great. So I'll tell you what, this has been a really super episode, and I want to thank everybody for joining us today. And I certainly look forward to having you back at another one of our HR Investigations podcasts. See you, everybody. Until next time.
Thanks for joining us today on the HR Investigations podcast. Be sure to subscribe, like, and share the show with any colleagues who will benefit from our strategies and solutions. For free bonus resources, simply visit hr-investigations.com. And remember, if you'd like some help with improving your investigative skills, or if your organization is in need of an external investigator to help with a case, please get in touch with us. Thanks for listening, and we'll see you in the next episode.